Good afternoon from Hong Kong, everybody, and welcome to today's webinar on domain name dispute resolution. I'm Sarah Grimmer, Secretary General of the HKIAC, and it's a great pleasure for us to have you with us. Today's webinar is the third in a series of 3 webinars dedicated to the 3 elements to be satisfied in a successful challenge to the registration of a domain name. The third element is that the domain name has been registered and is being used in bad faith. Today's webinar is going to take the form of 3 short presentations, firstly myself, and then our 2 guest expert speakers whom I will introduce shortly. And the last part will be dedicated to your questions. So please do send in your questions through the Q&A function. You can do so and I will deal with those on an anonymous basis. And even if we don't get through all of your questions during the webinar today, we will answer you after the webinar. So this is the final webinar of our series on domain name dispute resolution, looking at the 3 elements, but we will also be running this series in Mandarin Chinese from September through early November. And the first webinar in that series will start on Monday, the 28th of September at this time. And there will be details at the end of this webinar on the timing for that webinar. And if you're interested in looking back at what we've done, you will find the whole series available on our audiovisual library on our website, where you will also be able to find all of our other webinars that we have produced in 2020. Today's webinar will be recorded and the slides will be available there. So first, let me introduce our 2 expert guest speakers today. Our first speaker will be Ms. Karen Fong. Karen is a partner at Keystone Law, a leading UK law firm, and she is a specialist in IP and commercial law with over 20 years experience, and she's practiced in London, Hong Kong, and in Singapore. She's advised well-known brand owners as well as startups and individuals on all aspects of business, including the protection and exploitation of IP rights in the UK and internationally across a broad range of industries. She has both non-contentious and contentious experience. She's experienced in litigation at all court levels in the UK and has experience in mediation and in arbitration, particularly with respect to disputes involving trademarks, domain names, copyright, designs, database rights, confidentiality, and trade secrets. And Karen is a domain name panelist for the ADNDRC, the Asian Domain Name Dispute Resolution Center, as well as HKIAC and WIPO. Our second speaker on this webinar is Professor Zhao Yun. He is the Henry Cheng Professor in International Law and Head of Department of Law at the University of Hong Kong. His specialization areas include space and telecommunications law, international economic law, e-commerce law, and dispute resolution. He currently holds a number of important roles. He is the representative of the Regional Office for Asia and the Pacific of the Hague Convention on Private International Law. He is a standing council member of the Chinese Society of International Law, and he is chair professor at Xiamen University, as well as Tianjin University of Finance and Economics. And he serves as a domain name panelist for the ADNDRC, HKIAC, and CTAC. Next slide, please. Next slide. Okay, so as I said, this is the 3rd webinar in a series of webinars that has looked at the 3 elements in order to file and obtain a successful domain name complaint. And these 3 elements have been represented as they appear under the UDRP policy. We're going to come back to this, but before I hand over to our experts, I would like to give a brief introduction to HKIAC's work. Next slide, please. So HKIAC is a domain name service provider that is mandated to provide services in respect of multiple policies. And much of our work takes place under the auspices of the Asian Domain Name Dispute Resolution Center, which is one of the 5 ICANN accredited UDRP service providers. HKIAC helped establish ADNDRC back in 2001, and ADNDRC is comprised of 4 offices operating across Asia in Hong Kong, Beijing, Kuala Lumpur, and Seoul, and HKIAC, as you may guess, is the Hong Kong-based office. We also provide domain name services under our own auspices under the CNDRP and HKDRP policies, which apply to country code top-level domain names .cn and .hk. Next slide, please. Here before you, you have a list of all of the policies under which HKIAC provides services, and marked in orange are those 3 most common policies under which we work. Next slide, please. Let me give you a bit of a snapshot of our work through our case statistics. In 2019, we handled 182 domain name disputes in total. Most of those cases were UDRP cases. So you see there approximately 58% of cases were UDRP cases. And then next were CNDRP cases, 38% were CNDRP cases, and 4% were HKDRP cases. And you have the raw case numbers there. And this is a very typical breakdown that we would see amongst our caseload for any given year. Next slide, please. Where do the parties come from in our cases? In 2019, we had parties involved from 34 different jurisdictions. The top 10 geographical origins are listed there on the map, and they're reflected by the size of the coloured space on the map in terms of how often they were seen in our cases. The top 10 geographical origins were widely spread across Asia, the US, the Cayman Islands, and the BVI, and Europe. And then in the boxes to the edges, you have the split between the top most frequent complainants on the one hand, and then the top most frequent respondents on the other. With respect to complainants, you see that the top 6 were mainly from the US and mainland China. And then with respect to respondents, you see that they were mainly from China by quite a large margin, and then a number of other Asian jurisdictions. Next slide, please. What about the language of proceedings? In 2019, proceedings in Chinese, or proceedings that had an element of the Chinese language involved, made up 2/3 of our cases, whereas English made up approximately 1/3. What was interesting is that in the first half of this year, we also saw different languages in cases, some languages we don't usually see. For example, we had cases filed in Japanese, Korean, and in Russian. And at the Secretariat, we are proficient in Korean and Russian, so we were able to provide full services in those languages. But as you can imagine, what languages we see in our cases has serious implications for how we staff our Secretariat in terms of providing the relevant language support from within the Secretariat. It's also relevant when appointing panelists, whether as the HKIAC office under ADNDRC or under our own auspices, but we often need to draw from a pool of panelists who are proficient in Chinese or bilingual, and who are obviously qualified to sit as a domain name panelist, and who are neutral and independent. Next slide, please. So who do we appoint as domain name dispute resolution panelists, and how often? As you can see from the slide, in 2019, we made 195 appointments. Most of those were in UDRP cases, in which case we appoint from the list of panelists that is maintained by the ADNDRC. And then other appointments were made under the CNDRP and HKDRP policies. And in those cases, we appoint from the HKIAC panel. And both ADNDRC and HKIAC have processes in place to add qualified people to the respective panels, and all of those details are available on the respective websites. You can see from the second pie graph that in the vast majority of cases, we appoint a sole panelist. And it's only in the few cases that we would appoint a 3-member panel, and that is where one of the parties so requests. And then on the right-hand side, you can see the list of the geographical origins of the panelists we appoint. And you see that Hong Kong permanent residents, passport holders, or those resident in Hong Kong are the most frequently appointed. And that is really a reflection of the linguistic demands in our cases, very often requiring bilingual Chinese-English panelists. Next slide, please. What are the typical outcomes in our cases? So in 2019, 190 decisions were rendered, and across all 3 policies reflected here, 180 decisions were to transfer the domain name, and that corresponds to an overall success rate of 95%. Then you will see that there were 5 decisions to cancel the domain name, so a much smaller proportion. And then also a very small proportion of cases where there was a denial by the panel to transfer the domain name to the complainant. So overall, a very, very high rate of success. And as you are no doubt aware, all of the decisions are made available online and open to the public. So that provides a very valuable resource to parties, to counsel, to panelists in respect of how decisions are being made. And one further statistic for you to note is that we've measured the average duration across our cases, and that has averaged across all of the policies at 54 days. So that's under 2 months. And there you see also the average duration with respect to each individual policy over the year 2019. So a process that has a very high rate of success, and in terms of procedure is swift and efficient. Next slide, please. What does HKIAC do as a service provider? Let me just walk through a few of the key aspects of our services in this respect. First of all, when a request is made to us, the first thing we do is we request the registrar to lock the domain name to ensure that the status quo is maintained for the time over which the domain name dispute will run. And then we will also work with the registrar to confirm the respondent's contact information. We also review the complaint for compliance, and once those processes have been completed, we will give notice to the respondent of the complaint. And then the respondent has 20 days to file its response typically. And over this time, we are always monitoring the timelines for the next step in the process. We are acting as a conduit for communications where necessary. Once the response is filed or the time limit within which the response is to be filed lapses, we perform one of the most important functions that we have under our role, and that is to appoint a panelist. And we do that within 5 days of receiving the response or the expiry of that time limit. Once we have appointed a panelist, we then transmit the file immediately, and it is then for the panelist to issue their decision within 14 days, barring any exceptional circumstances. Once that decision has been made, we will notify it to the parties, to the registrar, and that will then enable the implementation process and also to ICANN. And finally, to close out the proceedings, we will pay the panelist fees and make sure that the decision is publicized without delay on the appropriate website. Next slide, please. Okay, so let's turn back to the topic for today. For a complainant to obtain the transfer of a domain name to it under any of the major policies, UDRP, CNDRP, HKDRP, it must satisfy all 3 elements. And the third element that we'll be looking at today is that the domain name has been registered and is being used in bad faith. Next slide, please. I have set out here the exact wording of the 3 policies in respect of the third element. It is identical as between UDRP and HKDRP, but not identical in respect of CNDRP, and we can discuss later if that makes any material difference. But one thing that is different about the bad faith element compared to the first 2 elements is that each of these policies provides additional guidance in terms of what may constitute evidence of registration and use in bad faith. And I've set out there the provisions, the relevant provisions. So Article 4B of UDRP and HKDRP and Article 9 of CNDRP. And while these lists are not exhaustive, they do address the most common evidentiary bases for a finding of bad faith. Our first speaker, Karen Fong, will focus on the evidentiary bases for bad faith expressly identified in the policies. And Professor Drao will focus on additional possible bases and considerations for a finding of bad faith. So we will cover the full gamut. Professor Drao will also touch upon another aspect of domain name dispute resolution, which, while it does not belong to this third element of bad faith, it does examine bad faith in domain name dispute resolution proceedings from another angle, namely that of reverse domain name hijacking, where a complaint is brought in bad faith. So without further ado, let me pass over to Karen Fong to focus on the evidentiary bases for bad faith that are expressly provided in the policies. Thank you, Karen.
Thank you, Sarah. Good morning, everyone, or actually it's good afternoon, depending on where you are. It's 8:45 in the morning for me here in London. I am working from home, but I promise I'm not in my pajamas. I'm actually even wearing shoes, especially to do this talk. So thank you, Sarah, for the introduction. It's a real pleasure to be speaking to all of you today, together with my lovely panel, Sarah and Professor Zhao. Okay, so Sarah has already covered the first two, or briefly covered the first two elements, and so we're going to jump right in and look at what it means to act in bad faith. So the complainant has to prove on a balance of probability that the domain name has been registered and is used in bad faith. Sarah has already mentioned that the UDRP and the HKDRP has the conjunctive and in relation to registration and use, and the CNDRP, the test is disjunctive, where the complainant need only show that it's either registered or has been used in bad faith. So as Sarah has mentioned, here you can see paragraph 4B of the UDRP, which lists the 4 non-exhaustive circumstances, which, if proved, is evidence of bad faith registration and use. Next slide. So I'm going to briefly talk about the policy criteria and evidentiary framework, which is actually a euphemism for, panelist pet peeves, okay? So in relation to bad faith, what we mean by bad faith is that the respondent somehow takes unfair advantage of, or abuses, or otherwise engages in behavior that is detrimental to the complainant's trademark. So the burden of proof lies with the complainant. So if you are a complainant or acting for a complainant, it's really important to submit evidence to support your statements. Okay, just allegations, unsupported conclusory allegations is not sufficient. An example of a case that you can read, WIPO case number D200986. Now this case basically was concerned 19 domain names, and the complainant had alleged that all these domain names were connected to websites which bore the complainant's trademark and logos, but they only submitted a screenshot of one website, and the other 18 websites were disabled after the complaint was filed. So even if the panelist was minded to, it was not as if the panelist could actually check whether the statement was true or not. So be very careful, and please, as Sarah said, the incidences of getting a finding in a complainant's favor is really high. So the bar is, the bar is not that the bar is set low, but it is usually, in the majority of cases, it does involve cyber squatters, so getting the evidence is not difficult. Next slide, please. There is a single round of pleadings, so be thorough and anticipate the likely plausible respondent defenses with supporting arguments and evidence, because it's only in exceptional circumstances that you do get a second bite of the cherry. Now, having your key information in the complaint or the response rather than the annexes is really important. The date of the complainant's trademark registration matters when it comes to a finding of bad faith. So make sure it's in the complaint rather than buried somewhere in the certificate of registration in the annexes. Okay, so that's enough from me for whinging. Sarah, if I do go on too long, feel free to mute me. So if we go to the next slide, we're going to look at the first circumstance which evidences bad faith, which is the registrant's intent to to sell a trademark. So in the, if you read the policy, it basically says that the complainant has to show that the respondent has registered or has acquired the domain name primarily for the purpose of selling, renting, or otherwise transferring the domain name registration to the complainant or a competitor of the complainant for valuable consideration in excess of the documented out-of-pocket costs directly related to the domain name. So now this covers all forms of solicitation. It is very fact specific. To be very clear, registering for subsequent resale is not of itself bad faith. Lots of people who have legitimate businesses do just that. So these are, on this slide, I have listed some of the factors which evidences this particular limp of paragraph 4B, 4B. So they're not, again, they are not exhaustive. So first factor, likely knowledge of the complainant's rights. Now, in this case of BuyerMonsanto.com, Bayer, the owner of the famous Bayer trademark, they announced that they were making a bid for the company Monsanto. And on that very same day, the respondent registered the domain name BuyerMonsanto.com. Now, the panel found in this case that it was, it suggested opportunistic bad faith. There was also evidence that this respondent had a habit of registering domain names of famous third parties. And so therefore, the panel in this case found that the registrant had registered the domain name primarily for the purpose of selling or otherwise transferring the domain name to the complainant. In all these cases that fall within this limb, generally there is an offer to sell for a particular amount or name your price type thing. The second factor, distinctiveness of the complainant's trademark. I've put down two cases which shows contrasting positions. Now, for the first case, Major.com, the complainant had used the name Major Wire and Major as a corporate and business name in the course of trade for over 150 years. And it did have trademark registrations in the US and Canada for the mark Major. But the registration was a registration of Major together with a logo, and it also included a disclaimer for the word Major. Now, the respondent was in the business of acquiring and selling domain names, and they bought Major.com, which was left inactive for a number of years. So when they were contacted by the complainant, they offered to sell the domain name for $115,000. Now, in relation to bad faith, the panel found that there was no bad faith in this case, because although the complainant had acquired goodwill and reputation in the industry and the market in which it operates, Major is also a common English word. And unlike Apple, the panel said the mark had not acquired that sort of level of distinctiveness globally. Also, the respondent was based in a different country from the complainant. There was no evidence that the respondent was targeting the complainant or even aware of them at the time. So therefore, the panel found that the respondent was reasonably entitled to acquire the domain name containing this ordinary English word Major on a first come, first served basis. The second case, which I'm going to talk about, MoveBoots.com, that is, has the much more sort of like common scenario that you would find where the complainant, a seller of footwear, had trademark registrations for Moo all over the world, including China, where the respondent was based. And the respondent had asked for $1,000, and the panel found that the registration was for the purpose of selling to the complainant for an amount more than the out-of-pocket out-of-pocket expenses of the respondent. Another factor which comes in to be helpful in a complainant making its case is if there's a pattern of abusive registration. We've already talked about that in the Bayer Monsanto case. And then, of course, where the website content actually targets the complainant's trademark. Another factor is how about the case where there is a threat to sell to the highest bidder or transfer to a third party? So not an offer to sell to a complainant or the complainant's competitor. So in this case of bmwdriveschool.com, the respondent was a driving school based in Australia, and it had registered many domain names like forddriveschool.com, toyotadriveschool.net, and in its correspondence with BMW, the respondent sent one of its emails said, "I simply want to inform you of this since I predict that by the end of January 2017, the rights to these domain names will no longer be in my name." The panel in this case didn't actually make a finding of bad faith under this particular ground, but it went for pattern of conduct and purpose of disrupting the complainant's business. It seems as if there are cases in which panelists would treat this threat of wanting to sell to someone else, not to sort of fall in this offer to sell to the complainant or the complainant's competitor, but that in any case, it was evidence that there was, it does demonstrate that the respondent was determined in some way or another to use the the domain name to extract some commercial advantage from the complainant or some third party who would then take advantage of the domain name's association with the complainant. You know, there was a bad faith finding, but on other grounds in this particular case. And then obviously the final point under this heading, if you fail as a respondent to explain the reason for registration and there is an offer to sell, that is also evidence of registering with an intent to sell a domain name under this limb. So next slide. And I will go now to the second circumstance under paragraph 4b, which is pattern of conduct. The complainant would have to show that the respondent has registered the domain name in order to prevent the owner of the trademark or service mark from reflecting in a corresponding domain name, provided that it is able to show that the respondent has engaged in a pattern of such conduct. So you definitely need to have more than one abusive registration, but and panelists have found that as few as 2 instances is sufficient to amount to a pattern of conduct. However, I note that you may want to note that in this particular case, WIPO case number D2010, the panel found in that case that they did not believe that the registration of 2 domain names rises to the level of pattern of conduct. So something to bear in mind. Very important that you research the registrant's history. If you want to go and if you want to go down under this limb, targeting a complainant's mark with multiple domain name registrations, obviously that is going to be very good evidence of that. An example is WIPO case number D2014-1550. There were 22 domain names here which the registrant registered of Instagram type domain names. Either some were typo errors and some were just, you know, different combinations of Instagram. And then another factor would be if a registrant registers registers lots of domain names reflecting the trademarks of many third parties. In this HKIAC case of Bulgari Hotel Beijing.cn, this was a case where the website that was linked to the domain name made it seem as if this was part of the Bulgari Hotel chain. And the respondent also had a portfolio of domain names which included many other well-known third-party trademarks in the hotel industry. In particular, I think they had Marriott, Four Seasons, Sheraton, and this was a case in which the panel found that it was sufficient to amount to a pattern of conduct. Now, as I said, very important to research the registrant's history, and one of the factors would be if there are prior UDRP proceedings where panels have found bad faith against the registrant. So I've listed a couple of cases here. In the Helmut Lang shop.com case, this was a case where the registrant had registered the domain names or incorporated the trademarks of many well-known designers and fashion houses like Jimmy Choo, Alice and Oliver, Oliver Brown. In the case of halleberry.com, the registrant had also registered the names of famous people, including Pierce Brosnan, Jeffrey Archer, and Tom Cruise. I mean, I did wonder when I looked at this whether Mr. Archer would be thrilled to be mentioned, you know, would be thrilled to be included in line with like Halle Berry, Pierce Brosnan, and Tom Cruise. I suspect that he may well be. Anyway, so that is a registrant's pattern of conduct. If we go to the next slide, we can now look at circumstance, the third circumstance, which is disrupting the business of a competitor. In this case, a complainant has to show that the registrant had registered the domain name primarily for the purpose of disrupting the business of a competitor. So typically in cases where panels have found under this limb, it is where the registrant conduct is directed at the same market as a complainant. Now the word competitor has been interpreted very widely. So it's not just a commercial or business competitor, but it includes the concept of a person who acts in opposition to another for some means of commercial gain, direct or otherwise. So often not that easy to find direct evidence. So one needs to provide evidence to infer that the disruption was the primary sort of purpose in registering the domain name. So some of the factors which have been proven to be sufficient to amount to evidence of disrupting the business of a competitor. Now, if you have links or it resolves to a complainant's competitor's websites, an example in the easyjet.net case, this was a case where I think most of you would have heard of EasyJet. It's a well-known trademark in the EU and the USA for and airlines. Now, the domain name in question had links to EasyJet's competitors like GoFly, and so the panel found that this was a clear indication that the domain name was primarily registered for the purpose of disrupting the business of EasyJet. Typo squatting or adding a generic or descriptive word. This is another common cyber squatter trick. So in the case of Travelex Forex, Travelex is a company that operates a currency exchange business, and it has a pretty well-known trademark called Travelex. So the combination of Travelex, the complainant's trademark, with a descriptive word Forex, a term that calls to mind the complainant's core business, was evidence that the respondent was seeking to disrupt the business of a competitor. And then the other case that I have put down here, which is expediatravel.com. And as you can see, the registrant had spelled Expedia, E-X-P-E-D-I-A, and changed it to expediatravel.com, just with an X without the E. And this, there was a finding of bad faith here as well. How about criticism sites? Do panels find that a criticism site amounts to a disruption of the business of a competitor? There are, with criticism sites, there are two views, and I'm just going to show you two cases where there have been two different findings. In the first one, quasizabantu.com, the activities of the complainant are that of a religious sect, and they claim rights to the name Kwasizabantu, which in Zulu means the place where people are helped. And the respondent established a website in which it criticized the complainant. And in this particular case, the panel found that the purpose of the registration was to disrupt the business of the complainant, and therefore it was bad faith. Now contrast this to equalitycharterschool.com, where the website was set up, probably it was believed by a group of parents. The respondent had not responded, so we're not so sure, but it was a non-commercial website which criticized this New York-based school. The panel found that the complainant had failed to establish that the respondent was a competitor, and hence there was no bad faith under this particular limb. If we go to the next slide. So this is creating the likelihood of confusion for commercial gain, which is the fourth factor or fourth circumstance where the complainant has to show that the domain name has been used intentionally to attempt to attract for commercial gain internet users to the respondent's website or other online location by creating a likelihood of confusion with the complainant's mark as to source, sponsorship, affiliation, or endorsement. So commercial gain, it includes just about anyone that may benefit financially from the website. Obviously, and a very important factor, if you can show actual confusion, that would be great. Pay-per-click sites, phishing sites, that is also evidence of creating likelihood of confusion for commercial gain. Redirecting to a respondent's owned respondent's website, and of course selling counterfeit goods, you know, that would be an illegitimate use and definitely creating likelihood of confusion for commercial gain. I've put down a number of cases. Do I have time to sort of go through them? Let me just go through one of them, and the others you can sort of look up. I'm quite conscious of the time. So with the ADNRC case of TikTokFamous.club, I'm sure all of you have heard of and probably have done your own sort of like TikToks. I did my first one a few weeks ago. Anyway, this particular website, basically the purpose was to help boost a user's popularity so that they can become a celebrity to impress their friends by gaining up to 30,000 followers. On the website, there was a text box requesting for the TikTok username of the users so that followers could be added to the account. And at the bottom of the website, it says that this website is in association with TikTok, and the panel found bad faith as the website was used as a bait, basically, to increase a user's following. And it was a case where the respondent was employing the fame of the trademark to mislead users into visiting the website instead of the complainants, and therefore it was bad faith under this limb. So I will stop here, and if you do have any questions, do ask us during the Q&A. So thank you very much, and I'm going to hand you over to Yoon.
Thank you very much, Karen. I'll just jump in there to thank you very much for the comprehensive overview of the evidentiary bases, and also the tips that are threaded through for users to take into account, and also the great case references for people that you can go back and look at through the slides. That's fantastic. So yes, let me now turn over to Professor Zhao. Thank you.
Thank you, Sarah. First of all, I would like to thank the HKIAC for inviting me to speak in this webinar. Karen has given a very excellent presentation, I think, regarding the situations or examples of cases, situations that has been listed in the policy. The UDRP provides a non-exhaustive list of examples of bad faith. The burden of proof lies with the complainant. So the element of bad faith should be supported by arguments and available evidence. The panelist will be able to make possible inferences from relevant facts and circumstances, which will satisfy the element of bad faith. So relevant facts and circumstances include, again, I think these are non-exhaustive lists, which are put on relevant factors that could be taken into consideration. The first one is regarding the nature of the domain name. So for example, a typo of a widely known trademark or addition of generic terms to the trademark. Second, the chosen top level domain name, particularly where corresponding to the complainant's areas of business activities or a natural zone of expansion. Third, the substance of the website. So the panel might look into the contents of the website. Is there any change to the contents, and when the changes happen, etc. Fourth, the timing and circumstances of registration. So for example, the domain name was registered after the news of the launch of major products, or when the complainant fails to renew the domain name, etc. Fifth, the respondent's pattern of targeting marks. Actually, Karen has also briefly mentioned about the pattern of the registration. So here, we can find out that sometimes the respondent register the domain name in the common areas of commerce or intended consumers, or for the certain areas. So we will look at the pattern of registration of the respondent. And sixth, clear absence of rights or legitimate interests with no credible explanations. So that means we basically have no way to understand why he registered. And lastly, evidence showing that the respondent targets the complainant, etc. So I think these are the few factors that panels will continue to look at, apart from the list of examples that have been put out in the policy. The panel will look at other factors which may lead to the conclusion of the existence of bad faith. So I will have one case to elaborate. So next slide, please. So I use this one case to elaborate Home Interiors and Gifts Incorporation versus Home Interiors. So the respondent registered Home Interior and Gifts.com. When we look at the complainant side, the complainant fails to prove any of the specific indicators of bad faith which were listed in the policy. But the panel continues to examine other factors and in the end makes a conclusion that that's bad faith. So these are the 3 points that the panel has put down in the decision. The first one, the combination of descriptive terms, home interiors and gifts, into one phrase result in a name that is more distinctive than descriptive. And the internet users are more likely than not expecting to arrive at a website hosted by the complainant, which is also holder of numerous registered marks since 1958. Second, the gtld.com, so this top-level domain name suggests a commercial enterprise bearing the trade name of the website host as a second legal domain name preceding the .com. So basically, this domain name was registered for commercial purpose. Third, the fact that the respondent has posted only a account at the website which records traffic to the site is tantamount to an advertisement that the website is for sale and is an indicator of its value. So the panel looks into these 3 major areas of issues and came to its conclusion that that's bad faith. So next slide, please. So now, I noted that various panelists have been using knew or should have known criteria to decide on the existence of bad faith. So that's an actual or constructive knowledge. Where the complainant's trademark is widely known or highly specific, and the respondent cannot credibly claim to have been unaware of the mark, panels have been prepared to infer that the respondent knew or should have known the complainant and its trademark. The registration of the domain name per se will constitute bad faith. This will include the discussions on the reputation of the complainant and its trademark, the strength or distinctiveness of its mark, etc. Furthermore, the panelists has dealt with the issue of willful blindness. The panel will look to the facts of the case to determine whether the respondent has undertaken good faith efforts to search available database to prevent possible abuse of registrations. So next slide, please. Now I move to another issue regarding passive holding. I still remember, I think in the last 1 or 2 decades, when I served as a panel, I can clearly noted the change of the bad faith by the respondent. I remember around a year or probably before 2010, many cases I noted that the respondent will send email or contacted the complainant regarding the sale of the disputed domain name at a high price. But afterwards, or in the last few years, I noted these kind of cases decreases, but more cases are relevant to the passive holding. Now the position is quite clear now that the passive holding will not prevent a finding of bad faith. The panels were looking to the totality of the circumstances to make the decision on whether there's bad faith or not. So I list some factors for consideration. One is regarding the degree of distinctiveness or reputation of the mark. Second, failure of the respondent to submit a response or evidence of good faith use. Third, the respondent concealing its identity or use of false contact details, and implausibility of any good faith use. So the panels will be able to look at these factors and any other relevant to the case to make the decision. So now let's move to the next slide to look at some cases regarding the failure to submit the response. In the case Alcoholic Anonymous World Services Incorporation versus Raymond, in this case, the panel made it very clear that the respondent's failure to respond to the complaint allows the inference that the evidence would not have been favorable to the respondent. And in another case, the Noodle Time Incorporation versus Max Marketing, the panel says the failure to respond should be considered as an admission that such claims are true. So basically, we can find out that the panels will be able to look into relevant factors to find out the bad faith, even though the situation belongs to passive holding. So the passive holding will not prevent the finding of the bad faith. So now, next slide, please. Another issue that arose is regarding the retroactive bad faith registration. That means registering a domain name before the trademark rights accrue. Normally, there will be no element of bad faith. But there are also situations when the panels find the existence of the element of bad faith. So for example, the domain name registration in anticipation of trademark rights. The elements to prove this point actually can include, so for example, the domain name was registered shortly before or after the announcement of merger of a company, or there's insider knowledge, or there's a wide media publicity or attention, or following the complainant's filing of a trademark application. So under these circumstances, the panel will be able to decide on the existence of element of bad faith, even though the domain name was registered before the registration of the trademark. Next slide, please. Now I move to the very important issue regarding the reverse domain name hijacking. On the one hand, there are bad faith registration of domain name, but on the other hand, the complainant might bring in the cases in bad faith. So if the complaint was brought in bad faith to harass the domain name holder, then this will be considered as an abuse of the proceeding. Normally, we would expect the respondent to prove the complainant's bad faith. That means we would expect the respondent to submit a response. But we must note that even without response, the panels sometimes will also find itself in a position to decide on the existence of reverse domain name hijacking. In my experience, actually, I have always put a rather high threshold in determining the existence of reverse domain name hijacking. Mere lack of success is not sufficient for a finding of RDNH. The UDRP or CNDRP, all these policies has no clear rules regarding what will constitute RDNH. But the panel will be in position to look into relevant elements to decide on this issue. So for example, the complainant knew it could not succeed as to any of the three elements, or provision of false evidence or attempt to mislead the panel, or provision of intentionally incomplete material evidence, failure to disclose that the case is refiling, or basing on only the barest of allegations without any supporting evidence. So when we look at the UDRP and also the rules for the UDRP, the picture is quite clear that the RDNH is not encouraged. The rules itself has made it very clear that the panel, after considering the submissions, if they found that the complaint was brought in bad faith, for example, in an attempt to reverse domain name hijacking or was brought primarily to harass the domain name holder, the panel shall declare in its decision that the complaint was brought in bad faith and constitute an abuse of the administrative proceedings. So I put next slide, please. So this is a case which I did a few years ago. So in this case, basically the respondent requested to the declaration of RDNH. But when looking at the whole picture of the case, this request was rejected. The factors that was considered was as follows. Though the domain name was registered before the trademark, the complainant was set up in 1996 and the trademark was registered in 2005. So the domain name was registered between 1996 to 2005, but actually the complainant has been in functioning already. Second, the complainant's argument under a required element of the UDRP fails, but not by such an obvious margin that the complainant must have appreciated this would be the case at the time of filing the complaint. Third, there's a question of clean hands or factual accuracy on the part of both parties. Actually, in this case, the respondent has set up a website which is providing the same services of the complainant. Fourth, the panel cannot find that the complainant knew or should have known it would not succeed. Many cases which appear so obvious to the panelist or one party may not be the case to the other party. So based on the analysis, the panel rejected the respondent's request to declare RDNH. So finally, I will, next slide, please. Finally, I very briefly talk about the problem with the UDRP or discussions on further development of UDRP. One is regarding the mechanism is fair or not. I think as Sarah has mentioned that the success rate was quite high. So there's some concern whether the UDRP is more favorable to the complainant or not. But this, of course, there are various factors to take into consideration. Actually, in 1999 to 2000, there already has some kind of discussions. There are various reasons why the success rate was high. Nothing to do with the fairness or not. Second, bad faith in registration and or use. Karen actually have very specifically picked up the issue and or, and also we can find out the differences between UDRP, CNDRP, and HKDRP in regard to and or. So I think this issue probably we will have to clarify in the future. Third, regarding the payment of whether now the complainant will pay the fees, but in the future, whether the loser should also pay or not. That's something for consideration. The fourth, regarding the appeal, whether there's possibility to set up the appeal system within the UDRP. And fifth, long deadlines for response. Now the respondent has 20 days to respond, whether it's too short or whether we need to provide longer period of time for response. And finally, the UDRP has been rather successful, has resolved so many cases. So whether it's possible to extend to other areas, which will be a very important aspect for the further development of ODR. So with this, I conclude my presentation and pass the floor back to Sarah.
Thank you very much, Professor Zhao, for that very insightful presentation, especially with respect to the historical perspective that you're able to give. So we have a few minutes left now, and what I would like to do is we have a couple of questions. Well, we have 4 questions on the board, and what I would like to do is start by posing a question to Karen. The question is this. If the respondent puts a disclaimer on the web page of a disputed domain name, can that be considered as an indication of good faith, or I guess enough for a finding, for not finding that there is bad faith? And Karen, yep, okay.
Thank you, Sarah. Well, a very lawyerly answer is it depends. In cases where the respondent appears to otherwise have a right or legitimate interest in the disputed domain name, and there is a sufficiently prominent disclaimer that could potentially lend support of circumstances suggesting its good faith, But I think you've done do look at the case of Oki data as to how do you get legitimate rights or legitimate interests, etc. But on the other hand, where you have the overall circumstances point to the respondent's bad faith, just because you do have a disclaimer, that is not going to be sufficient to cure the bad faith. And in such cases, often the panelists have also found that the respondent's use of a disclaimer is an admission by the respondent that users may be confused.
I see.
Thanks.
Thank you. Professor Zhao, just want to pick up on one of the topics that you covered that with respect to passive holdings, because we have a question here which is related. The question is, if the disputed domain name is not actively used and the registrant has not taken any action to sell the domain name, can the bad faith element be established simply by showing evidence that the registrant is a cyber squatter?
Thank you. So this passive holding issue, as I very briefly mentioned, that the passive holding will not prevent the panelists from finding the existence of a bad faith. So there are indeed many occasions when the domain name holder passively holds the domain name without doing anything. It did not set up the website. It did not really take action to sell the domain name, etc. So the panel will be able to look into various factors to decide whether that's bad faith or not. So for example, in many cases, I have been using the know or should have known elements or standards to decide on the existence of bad faith. If the trademark is very well known, very famous, it has a high reputation in a certain area, in a certain region, or all over the world, it's simply not possible for the domain name holder to be unaware of the existence of the complainant and its trademark. So in that case, we will decide that since the respondent has no rights or legitimate interests in the domain name or major parts of the domain name, he purposely registered this domain name. So this kind of action, the registration per se will constitute bad faith. So that's one element that we will look into, but other factors, of course, we will also look into. So for example, when the respondent fails to submit a response, or the respondent purposely hide its address or identity, etc. So basically, the panel are free to look into all these factors to decide on the existence of bad faith. So thank you.
I see. Thank you very much. We have another new question which has come up, and I'll pass it on to either of our panelists if you're able to answer, and that is, when are the UDRP reforms expected to be able to be implemented? Does anyone have insight on that?
Possibly, I think, because I think I pick up the issue in the last slide, I indeed are looking to the ongoing process to look into whether there's a need to further develop the UDRP. In 2020, this year, an ICANN working group will begin to look at whether UDRP, in connection with other ICANN created rights protection mechanism, so collectively fulfills the purposes for which they were created, or whether improvements are needed, including to clarify and unify the policy goals. So the work has started, but I wouldn't say that's a clear time frame when the reform will be implemented, but the process has started. And I think I'm quite optimistic to look into several issues that are listed in my PowerPoints to take place. So for example, when it comes to bad faith in registration and or use, actually this issue has been discussed on various occasions, whether we simply use or or still keep it N or not. So I think this will simply depend on the process of the working group. Once this has done, we will have clearer ideas on how to move forward in the next step. There are always pros and cons regarding the proposals. So for example, appeals. It's good to have some appeals within the UDRP, but this also will drag on the whole process. But on the other hand, if we leave to the court, then the whole process will be even longer. So I think now the working group will look into the pros and cons of all these proposals to decide on which proposal should be adopted in future.
Okay, that's really interesting. Thank you, Professor Zhao. Maybe it's too
can
early.
I jump in here?
Yes.
To make a comment? I think there are certain I think possibly lots of domain name panelists in sort of meetings that I've attended. I think that the view of these reforms, it looks like it's inevitable that they will come, but I don't think it's very popular because, you know, the UDRP has been around for 20 years and most people would say that it's worked really well. And there is a very, there's the jurisprudence supporting you know, all the various sort of limbs, etc. That's very well developed, and so there's the question of it, if it ain't broke, why, you know, why are we sort of fixing it? So just a quick view here.
Yeah, okay, that's really interesting. Do either of you know if there will be an official public consultation period for any changes to the policy or rules and so forth?
I think to my knowledge, I think the working group is starting to work to discuss, and I assume I think in the near future there should be some consultations coming up to the panel, to seek views from the public, from the panelists. I'm sure, I think as Karen has said, I think the UDRP has been in existence for 20 years, more than 20 years, and has been very successful. There will be definitely different views. So I think the consultation is will definitely be issued after the meetings of the working group, which was set up in 2020.
Okay, wonderful. Thank you very much for those insights. Well, it's just left to me now to thank both of you for your work, for your contribution, and for your time today. I think your presentations have been excellent and are really useful to all of the people who are attending, who will view later on. So thank you very much, Karen. Thank you very much, Professor Zhao. And now it's for me to say goodbye to our attendees and wish you all the very best wherever you are in the world. Thank you very much.